All right, welcome back to Double Fries No Slaw. Doug Rohan of Rohan Law. Man, it's been a minute. How you doing, Doug?
I'm doing great, TJ. Thanks for having me back on. Always a pleasure to sit with you and talk about Knowles and law stuff.
Yeah, no, I appreciate it. Especially jumping on the day before the holiday. Do you have any? Are you a hot dog eating contest type of guy, or what do you do on the fourth?
Sit by the pool, buy a bunch of fireworks. I'm the one responsible for neighborhood firework display, so we went and got those last year. Georgia has made it semi-legal, so it's nice to spend a couple $100 at Phantom Fireworks and let everybody come over and hang out in the front yard for a while.
Yeah, we're just trying to dodge rain. Like all the stuff
Oh
around here is
no,
getting canceled, and it happens every year on the 4th of July. But you know,
it's Florida, summer
yeah.
afternoons.
So we're like, all right, well, there's a 30-minute window where we can go swim and grill out and do fireworks all within that time, and then we'll just
Right.
watch The Sandlot on repeat, I guess, for the rest of the day. Um, all right, so since the last time we've spoken, and really just within the last, 2 days ago, the House settlement has gone into effect.
Mhm.
Not a lot of, I mean, not really a lot of breaking news. Like a lot of people understood what was coming there, but do you want to just give a real high level overview of what's maybe changing from an NIL to an internal standpoint?
Yeah, the biggest difference is that the universities can now pay the players directly with a budget of $20.5 million. Matt Winter did a great job in his article yesterday. That's something I want to make sure that we point out. This does not necessarily need to be from the athletic department's budget. The athletic department's budget was used across the country to generate the average number, and that was the basis for the $20.5 million. But as these universities try to decide how they're going to come up with these funds, it's not strictly limited to the athletic budget as the source. So one of the things that the state recently did, and the Board of Governors were talking about it, is the state is allotting some state revenues to go towards the state university for paying those funds. And then, of course, we still have to get clarity on what's happening with the collectives outside of the university funding. Battle's End doesn't go away. Battle's End is presumably going to continue to supplement and pay some of those funds. There has been discussion on both sides. Admittedly, I don't know specifically where this is going to end up, but it seems like we're leaning towards, as long as it's reasonable and justifiable in true marketing terms, then the collectives are going to be able to supplement what these universities are going to be providing directly.
It sounds like more court eventually coming down the road.
We've already had 4 appeals
Yeah.
filed as of last night against the House settlement consent agreement. So yeah, it's look, the billable hour is undefeated. At the end of the day, that we know who is making some money off of these actions that are going to be moving forward, and attorneys certainly stand to gain some niche revenue in this new cottage industry.
Um, you talked about the collectives. What I found interesting, I don't know if you saw this, UGA shut down their collective. I saw UCF did the same thing, which is an interesting strategy, and maybe doesn't make headlines if it's just UCF, but for a football power, an athletic power of UGA to do it, I found somewhat interesting. I have no doubts that Georgia is still going to recruit and induce the way that we would expect them to. But to take the collective away is interesting to me. I
I
don't
think that
think
has
it's
a lot. I think it has a lot to do with the relationships, perhaps between these power players. Look, a lot of people moved into the NIL space because they wanted to have some authority, some control, some ability to um, shape the recruiting classes. And in those institutions where there was not good cohesion or good communication between the NIL collective and the university, I could see this being more of a political move from one standpoint. It might be a way for the university to regain control of those collectives, of those funds. But the other side is you kind of have to see what happened with FSU's first attempt at a collective and getting into some trouble with some rules. Perhaps especially the higher profile schools like University of Georgia want to try to minimize any risk or minimize any problems until the guardrails are more clearly defined. So by shutting down the collectives and only going through the university, they have an opportunity to, so long as they comply, make sure that they are operating more strictly within the bounds of what was intended by this settlement.
You mentioned the auxiliary funds that they can kind of use from the school side, the Board of Governors approving that. Obviously, a benefit to Florida, Florida State, UCF, USF, other schools as well.
Mhm.
when you think about Miami being a, kind of a two-parter, Miami being a private university, they could have just done that anyway, right? Like they didn't need the Board of Governors approval. So I wouldn't call it it's not like a disadvantage to them to not be under that state umbrella. It kind of just levels the playing field there. The second part of that though, I don't know if that's allowed in Georgia yet. Maybe you have a better pulse being there, but I mean, I would anticipate that other states do something pretty similar. Like Florida may have an advantage today, but I don't think it would be long before other states say, oh yeah, we're going to do that too.
So to answer the first part of the question, by being a private university, Miami, I think, does generally have an advantage because they can be more nimble. They can be more a rapid response in changes that need to be made because they don't have to go through the legislature. They don't have to go through the legislative process. Getting everybody to agree statewide on any changes can be problematic. Here, they were very aggressive in moving forward with this proactively, so that helped get ahead of the issue. But I would say, if anything, that's the advantage Miami has. They don't have to coordinate with any other organizations or institutions. They can just decide what's best for Miami. With respect to the state of Georgia and what's going to happen, our legislative session is typically in the February, March time period that it starts. It runs for 40 days. They're not consecutive, so it ends up going about 60 days in time total. So any changes that need to be made won't be made for the University of Georgia's benefit until we get to that legislative cycle late February and early March. Right now, Georgia was one of the leaders with Florida on this issue 5 years ago when they started talking about the tax implications and some of the disclosures. They haven't gone so far as to what North Carolina did this week to try to make the NIL contract exempt from disclosure. But Georgia is proactive. The state knows that University of Georgia is one of the premier programs in the nation. And so the legislature will work very quickly when they can to make sure that Georgia doesn't have any disadvantage with any of the other states.
And I mean, I'm not asking you to call a shot on 50 for 50, but I mean, would it surprise you if there were more than a handful of states that didn't end up doing kind of the same thing here?
Yeah, I mean, one of the biggest issues is the taxable nature of the income. If you have a state like Tennessee or Florida without income tax, but you have another state where there is income tax, that's a situation where there can be some negative recruiting. And we'll get into some ridiculous negative recruiting in a little bit when we talk about NIL contracts. But that's one example of how Tennessee can go and sit down in somebody's living room and can talk about, we're going to pay you $80,000. Georgia's going to pay you $80,000. But in Tennessee, we don't have state taxes. In Georgia, you do have state taxes. You're going to have to pay that 6%, 7%, 8%, whatever it is, back to the state of Georgia in order to legally accept the compensation for your services. So that'll be interesting to see how the states operate that. I do think I remember seeing some rumbling of some people wanting to exempt NIL contracts from being considered as part of the income. There is precedent for that. If you're injured in a car accident or a work accident, that's not taxable revenue because you're getting that in exchange for the damages that you suffered as a result of your accident. But I think it's a stretch to make the argument that the pay for play is not income. So yeah, it will be interesting to see how the states manage this in the next year or two.
Yeah, not to go too far off of a rabbit hole or tangent there because it doesn't really impact FSU other than maybe that recruiting advantage. But if I'm getting a marketing deal in the state of Georgia and I'm a singer, I'm going to want that, like if I'm a musician or an artist or a comedian or a painter or any kind of artist like that's getting an NIL contract, we don't call it NIL, but getting a marketing deal,
promotional deal.
Yeah, I would want that to be tax free. If you're looping hole in it for them, you need to do it for me. And
exactly,
like the SEC doesn't have enough benefits. We don't need to give them more. Let's leave that in and let us have one advantage to our name. All right, there's never really a boring moment, and if there's any shots that can be fired at FSU, they're going to be fired. There's some controversy right now with some of the contracts in this revenue sharing world that we live in that have come out in the last week or so. I think it was actually a week ago today that an article from Chris Hummer dropped with some agents of folks that represent FSU kind of calling out and questioning some of Florida State's tactics or strategies within the first draft or revision or what's maybe been sent out to some players of these revenue sharing contracts. Let's talk about this a little bit, Doug.
Well, first off, let's go back in time, take the time machine back to when we were told that the ACC grant of rights was ironclad. Until we see the contract, let's take reporting on the contract with a grain of salt. A contract is an agreement between two parties signed by both parties with some financial consideration exchanged. A draft, a proposal, a commentary about what might or might not be in some of those contracts needs to be taken with a grain of salt. That's my position right now. Once we see the contract, then we can have a deeper dive of what is actually in the contract. There was a blurb that was put up in the article. That was a fraction of a paragraph. It talked about what happens when the player gets injured. All it says is if a player gets injured, the school is still responsible for providing medical care. Okay, that doesn't sound bad. That's what would be expected. There is something in here that's a clause. A clause to what? Is this a definition of the term? Does somewhere else in the contract we have the phrase illness or injury impacting value? That all this does is says this is what is the school's obligation. It doesn't talk about what the impact is on the contract. It doesn't say that the contract is void or voidable as a result of any injury. It just says student athlete experiences any illness or injury which is serious enough to affect the value of rights granted to school under this agreement. That's a fraction of a sentence. That's not a complete sentence. Provided, however, that nothing herein shall affect or limit the school's obligation to provide student athletes with medical coverage of injuries sustained as a result of participating in that school's athletics as required by the NCAA. That is a complete sentence. So all this clause says is schools, whatever you contract, whatever you say, you still have to provide medical treatment for an injured player who blew out his knee while running down the sideline trying to score a touchdown. That doesn't say what the article alleges it says. That doesn't say what the headlines claim the contract says.
Yeah, what they seem to be alleging or implying or throwing out there was you get hurt, we're going to cancel your contract and you're not making any more money anymore. And we're going to throw you out on the street and kick you in the guts while you do while we do.
The ACC grant of rights is ironclad.
It's always easier to say that, right, before you actually break down what it is. What is somewhat unfortunate is though this stuff gets picked up, right? And people don't know the law, they don't know the contracts, they haven't seen the contracts, right? And then they opine on it. You even get really big names that end up coming on this. I want to play a quick clip and we'll talk about it when it's done.
Like, for one, they can extend me, coach. So say I have an amazing Heisman season, we win a national championship, outplayed my value, right? They can extend me without my consent. So now I'm getting underpaid. Then you talk about you could cancel my pay if I get hurt playing for you. You can fine me. I can't appeal it. I'm not signing that deal, coach. For one, I'm giving away all my leverage. Like, we talk about this new NIL era and this rev share era, like, there's supposed to be some give and take, some balance here.
If I'll make this statement, if that's legit, this goes through, which I'm so skeptical, then the days of Florida
legit,
State are numbered.
I'm skeptical.
He said, if it goes through, the days of Florida State numbered.
No. Back it up. He said, if this is legit.
Which he then admitted, like, I'm skeptical of it going through.
Why are we reporting on something that we don't think is actually legitimate or actually true? But let me go back and say this regarding the first part of the commentary. The object of an attorney representing a client is to draft an agreement that benefits his client. Now, he says this gives me the opportunity, give the institution the opportunity to extend without renegotiations. I have not seen that part of the contract published in any of the articles I've read about this alleged position. If this truly was word for word what is being alleged, we would see evidence of that in the publication. Instead, what we have is a game of telephone, perpetuated initially by a UF grad. If my sleuthing is correct, this goes back to a lawyer who has UM and UF credentials, so certainly no fan of Florida State. But even then, he reports something that someone else reports, that then gets put on a podcast. And it's a game of telephone. And who knows how much it has changed little by little over each of those transmissions. We don't have the contract. We don't know what's in the contract. We don't even know if the contract was signed by the athlete in question. Just because the attorney says, here, this is the contract we'd like you to agree on, that doesn't mean that there aren't negotiations to be had. That doesn't mean there aren't further discussions to shape that contract. So maybe I'll take it with a grain of salt. Maybe Florida State's attorneys pushed the boundaries a little bit too far in this initial proposal, but that doesn't mean it reflects the final agreement. That doesn't mean it reflects the negotiations. And most importantly, nobody that's talking about it knows what's actually in the agreement. So take it with a grain of salt. All this means is a 2-10 school is pulling a top 10 recruiting class, and they're coming for us. We're back, baby. The logo holds weight.
I want to go back to something you said. It is an attorney's job, and I'm paraphrasing because I'm not very smart, so remember word for word, but it is an attorney's job to draft a contract that is advantageous for their client. And at worst, and breaking that down even simpler, if Doug Rohan is representing me because I got in a car accident, I want him to ask for the maximum amount of money possible, even if it's unrealistic, right? Like, I want you to go for the moon. And if they settle for a little less, or if they cut it in half, whatever. But as an attorney at the same time, I want you to tell me, like, hey, you're probably going to get X, but we're going to ask for 2X. And if we get anywhere between X and 2X, then that's a win. If we go under X, then I was wrong, right? I'll own it. I'll fall on the sword and I'll tell you, like, maybe I overshot what I thought was realistic. But I want you to ask for 2X. Shoot, I want you to ask for 6X. Now, if that's the case, right, and I'm understanding that correctly, FSU's attorneys at worst probably asked for more than they ever thought that they could get. But if you can design a contract that is more advantageous to you than the other party, that's not necessarily an immoral thing. You're just, is that what just happens in every contract negotiation ever?
Right. And that's exactly what the articles are purporting to claim. Florida State is morally bankrupt for suggesting that they be able to keep a player for more than 1 year without renegotiating the terms. That's not morally bankrupt positioning. That's trying to gain an advantage, certainly. The same is true the other way around. What happens if the other party then hires an attorney? This is the reminder. Enter into contract negotiations with an attorney, because you never know what hidden items are in there. But I'm going to come back and say, you don't have a right to include that clause. We're not going to sign that. The FSU goes back and removes that clause or changes that clause. What happens if somebody gets hurt and is less valuable? What happens if somebody gets hurt and is paid a starting quarterback salary, only plays 2 games, and is out for the rest of the contract due to injury? There's a risk on both sides. Now, I don't believe that making an ask equals moral bankruptcy. The worst the other party can say is no. I'm a firm believer of that. I've lived my life by that. If that turns some people off, then it's probably because you're not a Florida State fan. That's why you're upset with it. If your university was doing it, like, yeah, we have to protect our interests. We have to protect our pocketbooks. So this is one of those criticisms where 90% of your perspective is dictated by your allegiance, not the law, not rational thought, not an independent, reasonable perspective.
Yeah, I think a lot of people, especially when it comes to the money side, and this is more just kind of getting onto maybe my own personal soapbox or whatever, I think they forget that, like, Florida State Athletics and Seminole Boosters, they are businesses. Now, Boosters is, there is a weird shade of like a non-for-profit, and I get that. But yeah, they are businesses at the end of the day. And they are, they're not, again, Seminole Booster specifically is kind of, but they're not necessarily a charity in the sense of, like, they're just trying to do altruistic work of being great people, like Metropolitan Ministries or like the Red Cross or something like that, right? Like, it is a very different distinction. And for a while, I think they did operate that way, where they were giving away, and they made money for sure, but where they were given scholarships and stuff. And now it is truly like a, you give me this, I give you this, right? It is a symbiotic, mutually beneficial financial relationship, which is a new era and has changed quite a bit. But I mean, there's a billion concerts in Atlanta. If an artist gets sick and doesn't perform at that concert, I mean, they don't get paid for it, right? Like they refund those tickets, And so I know that's not a perfect 1-for-1 comparison. There are, NFL players, if they get hurt, they get, their pay is, but that's been collectively bargained. That's a very different world. That's not a 1-for-1 either, in my opinion. And so I think a lot of people forget that this is a business, and Florida State trying to protect their interests, is not necessarily a bad thing, right? They're not morally bankrupt, by doing that.
I'd go a step further. Not only is this a business, but it's a new business created out of whole cloth. When we were back talking years ago about the ACC contracts and the FSU agreements and all these memorandums, we have 100 years of contract law upon which to base these negotiations, these discussions. This industry has not existed until the House settlement agreement was consented to. So everybody is testing the boundaries, pushing the edges. And for those who are claiming, oh, Mike Norvell used to be such a nice guy, but now he's a jerk because his job's on the line and he's pushing this, I'm pretty sure Coach Norvell has zero impact on these contracts' creation, shape, negotiations, other than saying, that's a player I want. I would like to invest money in that player. So the people who are haters, the people that are negatively recruiting, will of course try to make this far more of a big deal than it really is. None of this matters until there is a signed and enforceable agreement, and then we can actually see what the terms are, not what they are reported to be.
Yeah. Two points, and then maybe we'll wrap up here. But one, yes, Mike Norvell has, I can almost say with certainty, has no impact on this. However, whose picture was on the very front of the article when it dropped? I actually have spoken with Mike twice in the last 2 months. He is the nicest guy in the world, and I wish him all the success in the world, and I hope he's the guy to turn us around. But yeah, has nothing to do with it, but is an easy target right now, especially coming off a 2-10. The second point is, while we're here, we're not going to not crap on the ACC. The Big Ten sent out standardized uniform contracts for all revenue sharing for all of their members. And I'm not going to say, oh, Florida State did this and it's the ACC's fault. But you know who didn't do that? You know what conference didn't send out uniform contracts of, hey, guys, we're going to take the bull by the horns. We have done this as a conference. We're going to do this in unity and do it together. We want everybody to use this. The ACC didn't. And so, listen, if you want somebody to blame here today, it's not me and Doug. It's not Mike Norvell. Let's just blame Jim Phillips.
And once again, the ACC is a reactionary force that can't trip, stumble, fall their way into a correct decision.
Yeah,
that's what the bottom line is. What the conference is, the organization that's ultimately enforcing this settlement agreement, the House settlement agreement, and these contracts. Yes, there is the clearinghouse. Yes, Deloitte is going to be reviewing them, but it's the conference that's responsible for enforcing any of these actions against the contract. So, of course, a competent, well-run conference is going to be saying, this is what we're prepared to defend in court. This is what we're prepared for you to use. And again, we go back where we talked offline. Yes, there is room for negotiation. Yes, there is room for evaluation. People need to get their input. If you go to close on a house, the bank provides you with their contract. You can either sign it or not sign it. That is the contract. You don't get to hire your own attorneys to go through the $250,000 closing documents for your house because they've got 7,000 other closings that month. The NIL landscape is not the same. There is room for negotiations. Again, what the Big Ten is saying is this is the framework for what we expect to be able to support you as an institution. Go with this, but to the extent there needs to be some negotiations, report back to us what those negotiations are, and we'll decide as our attorney team whether we want to accept those changes or not. The ACC hasn't done it, so now it's each member institution responsible for coming up with their initial proposal, because that's what it is. It's not a contract. It's an initial proposal for the other party to review and evaluate.
Doug, any closing thoughts? Anything as we wrap up today?
I'm excited for the football season to start. I can't wait to see what these new versions of the Noles look like. I really am expecting good things and a big turnaround. I have confidence in the Alabama matchup. And again, I won't go so far as to predict a win. I think a win is possible. For Florida State, all we need to do is play well, make it competitive. Alabama has to win. If Alabama doesn't win, that's an indictment on DeBoer. That's an indictment on where they are post Saban. And it additionally makes us much more excited about the prospect of facing Miami at home 4-0 and getting to see, where this team is after the first quarter of the season's over.
Yeah. I'm riding with Tommy C. Bring them on, man. They can't stop them until they do. So
exactly.
Until I see it, I'm believing in QB1. So Doug, quickly though, before we go, a little bit about Rohan Law and then we'll wrap.
Rohan Law is your best friend on your worst day here in Atlanta, Georgia. We want to make sure that if you find yourself facing criminal charges or hurt at work, that you have a Nole that wants to come alongside you and help you out through a very difficult and challenging time. Otherwise, you can find us at some of the tailgates down for the season when it starts. We'd love to visit Tallahassee and spend some time with you all at your tailgate. And if you find yourself in trouble as you're driving to the different ACC institutions for the away games, let us know how we can help you out here in Georgia.
Yeah. A great Twitter follow as well. Twitter X, whatever we call it. Rohan Law PC. Doug's able to react to a lot of this stuff a lot quicker than we can get together. So make sure you're following there. And then, like you said, whether you're in Georgia or not, they've got a good referral network. If you find yourself in any trouble, hit up Doug. DM phone number is in the description, website as well. Make sure you reach out to our friends over at Rohan Law. But Doug, I appreciate you, man, for hanging out. Go Noles.
Go Noles.